Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 in Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You were asked to come here this morning for our arraignment docket. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. Your case is a misdemeanor case. Criminal cases are divided into either a felony or a misdemeanor. We only handle misdemeanor cases in this court. Your felony cases are handled in the district court. Now, if you had a felony case, there's a potential or a possibility that you could be sentenced to the state penitentiary. No one who have a misdemeanor case cannot be sent to the state penitentiary for a misdemeanor. However, you can be sentenced to the county jail for a misdemeanor offense if it is a Class A or a Class B misdemeanor. Now, your felony cases are normally referred to as your more serious criminal offenses. Your misdemeanor cases are normally referred to as your petty criminal offenses. Now, it doesn't mean that they're not serious, because all criminal cases are serious. If you have a felony case, your felony cases are divided into 5 categories: capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. And their range of punishment differs. Capital murder case, if you found guilty, you could get life or death. First-degree felony, minimum 5 years in the state penitentiary, maximum 99 years to life, or anywhere in between. And you could get a $10,000, a fine up to $10,000. For a second-degree felony, the range of punishment, minimum 2 years to 20 years in the state penitentiary, fine up to $10,000. For a third-degree felony, the range of punishment is minimum 2 years, maximum 10 years, fine up to $10,000. And for a state jail felony, the range of punishment is a minimum 6 months in the state jail, up to 2 years, a fine up to $10,000. Now, in this court, where we handle misdemeanor cases only, as I said earlier, you cannot be sentenced to the state penitentiary. However, your sentence can include, or you could be sentenced to the county jail. We have 3 categories of misdemeanor cases. We start at the top with a Class A, then we go down to a Class B, and then we go down to a Class C. Your Class C offenses are fine only. You cannot be sentenced to the county jail for a Class C misdemeanor. We don't have, normally the Class C misdemeanors are handled in the city court or the municipal court or the JP court, the justice court. For example, a speeding ticket is a Class C. You can be given a fine. Now, if the case is appealed from the justice court or the city court, it will come to this court. However, the range of punishment is still the same. We cannot sentence you to county time. However, you can be given a fine and court costs. Now, as I said earlier, the highest misdemeanor is a Class A misdemeanor. Now, the range of punishment is basically what your punishment may entail. If you're found guilty or if you're convicted of a Class A misdemeanor, your range of punishment can be anywhere from 0 days all the way on up to 365 days in the county jail, or anywhere in between. A fine from $0 to $4,000, or anywhere in between. For a Class B misdemeanor, your range of punishment is anywhere from 0 days to 180 days, which is 6 months in the county jail, a fine from $0 to $2,000 or anywhere in between. Now, the paperwork that you have in your hand is, I will go over that paperwork with you. And the first document is titled Judge's Explanation of Rights to Defendants Without Attorney. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number three, you may represent yourself. Those are your three options. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. The prosecutor is the assistant district attorney. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of this document, it reads, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If you've already hired an attorney, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you've already been appointed an attorney, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of those 5 lines, then you will sign your name at the bottom of this document on the line that is titled Defendant. And you will place today's date, which is August 10th of 2021. Now, for those individuals who will be representing yourself, you will also have to read and sign the second document. And I'll go over this document, and it reads, waiver of counsel for purposes of entering a guilty plea or proceeding to trial. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 10th day of August of 2021 by the County Court at Law number 2 of my right to representation by counsel, in this case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And then if that's your choice, you'll sign on the line that says defendant, and you'll place today's date, August 10th of 2021. Now, you also have a right to have a trial by jury. And what a trial by jury is, 6 citizens from Jefferson County will be selected to sit on your case, and they will decide whether or not you're guilty or innocent after listening to all of the evidence. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And if you do so, your case will come before the court or will come before the judge, either through a trial, the trial we call a bench trial, or if you enter a plea of guilty or no contest, it will come to the court by way of a plea or plea bargain. It can be an agreed plea bargain. An agreed plea bargain is where you and the state prosecutor have reached an agreement to settle your case. Or it could come to the court on an unagreed plea bargain where you and the state have not reached an agreement. However, you still would like to go forward with your plea of guilty and no contest and have the judge to assess the punishment. You also have a right to have witnesses to come to court. You have a right to call witnesses on your behalf. And what witnesses do, they'll sit in that chair over there. They can testify. They can testify for you or against you. You or your attorney, if you're represented by attorney, will be allowed to ask questions. We call those questions either direct examination or cross-examination. You also have a right to give up your right to have witnesses to come to court, or to waive your right to have witnesses to come to court. And by doing so, you will not be calling any witnesses on your behalf. However, the state will be calling witnesses for their case. You also have a right against self-incrimination. And what that means is you have a right not to testify in your case if you desire to do so. Now, you also have a right to waive or give up your right against self-incrimination, which means that if you desire to testify, you can testify if you waive your right against self-incrimination. You also have a right for discovery. Discovery means that you have a right to see the evidence that the state has against you. You have a right to see the documents, the videos, witness statements, whatever evidence that they have against you in your case, you have a right to see that. Now, you also have a right to waive or give up that right to see the evidence, which means that you have a right not to see the evidence if you don't want to have access to that evidence. Now, you'll have an opportunity, you or your attorney will have an opportunity to talk to the prosecutor. If you're representing yourself, you'll talk to the prosecutor. If you are represented by an attorney, your attorney will talk to the prosecutor to see if a settlement can be reached in your case. If a settlement is reached and you have agreed to it, we call that a plea bargain agreement. Now, that plea bargain agreement will come before the court. The court does not have to follow your plea bargain agreement. If the court does not follow your plea bargain agreement, then at that point, you will have a right to withdraw, which means you have a right to take back your plea of either guilty or no contest. Now, if the judge does follow your plea bargain agreement, and if you decide within 30 days to withdraw your plea or to take back your plea, because you believe that you have, for whatever reason, you would have to get permission for the court to appeal your case. Okay. And what an appeal is, it will be a higher court your case will go to a higher court to see whether or not you've been wrongfully convicted or whether or not the court committed an error by convicting you. That higher court that it will go to is called the Ninth Court of Criminal Appeals. It is located right above us on the 3rd floor. They will review your case. They will decide whether to grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court and give you and order this court to give you a whole new trial. Now, if they deny your appeal, Then within 30 days of them denying your appeal, you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is located in Austin, Texas, and it is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Pro se means you'll be doing it on your own without the assistance of a lawyer. And you'll be asking the Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court has committed an error by convicting you. If they can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. Or if they deny your pro se petition for discretionary review, then at that point, your conviction will stand. Everyone here have been arrested on your case and you're out on bond. And every day that you have spent in jail can be used as credit toward your punishment or your sentence. So for example, if you spent 5 days in jail, the state is offering you 5 days as a sentence in this case, then what will happen is you will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for time served. Now, if they're offering 6 days in jail, you serve 5, that means you have to serve 1. Every day that you spent in jail, you get credit at $100 per day toward your fine and court costs. So if you spend 5 days in jail, that's $500. If the state have offered you fine and court costs of $500, you already spent 5 days in jail, you wouldn't have to pay the $500 because you've already served 5 days in jail, and the 5 days in jail will be credited towards your fine and court costs. Therefore, your court costs will be taxed and retired. Now, if they offering a fine and court cost of $600, you did 5 days in jail, that simply means you would have to pay $100. If you cannot pay the fine on the day of the plea, then the court can give you scheduled payments or put you on what is called a payment plan. Now, let's say you can't pay on a payment plan either because you do not have money. Then the court can convert your fine and court costs to community service, which means you can work it off. Every hour that you do on community service is credited as $12.50 toward your fine and court costs. So if you work an 8-hour day, community service, that's $100. All right. So if you had fine of $500 plus, well, a fine and court cost of $500, if you did 5 days of community service, that will satisfy your fine and court costs. All right. Now, Jefferson County has a program. The Jefferson County District Attorney's Office has a program that is called pretrial diversion. Pretrial diversion means once you get into the program, your case is dismissed. And when you complete the program, you can get it expunged from your record. Expunged means to be erased, deleted, or wiped off from your criminal record. Now, in order to qualify for the program, you cannot have a criminal history. It has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. You have to have an attorney to assist you with the paperwork to get into the program. And as I said, if you get into the program, case is dismissed, you complete the program, you can get it expunged, erased, wiped off, or deleted from your criminal record. If you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program that is called Veterans Court. Veterans Court is a program for veterans. It's a diversionary program as well, which means if you get in the program, complete the program, the case is dismissed, you can get it expunged from your record. The only thing you have to do to get in the program is to be a veteran. Okay. Now, everyone here, as I said earlier, have been arrested and you bonded out. Now, you can enter today, you can enter one of three types of pleas today. You can enter a plea of not guilty, you can enter a plea of guilty, or you can enter a plea of no contest. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. If you enter a plea of guilty, then you're telling the court that you committed the offense that you've been charged with. Or if you enter a plea of no contest, then you're telling the court that you will not be contesting or you will not be fighting those charges. This court, County Court at Law Number 2, has a program that is called a CSI program. That is a program that I started within the first 100 days of becoming a judge here in this court. That program, CSI, stands for Community Safety Initiative. It's been around since March of 2017. The program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. The program addresses what we call recidivism. Recidivism means when people continue to commit crimes over and over. And so the way we address it is through this program. And basically, you know, with recidivism, there's a cycle. Normally, people who do not have an education can't get a job. They can't get a job. They normally turn to, they get depressed, turn to drugs and alcohol. Once they turn to drugs and alcohol, they eventually commit a crime. Once they commit a crime, they eventually get caught and do time. Once they do time, at some point they get out and then they're back into that same cycle. No education, no job, etc. And so where we address that is through our CSI program, stands for Community Safety Initiative. And the program that has been designed is through partnerships that we have made with local centers and agencies in Jefferson County. We have a partnership with Spindletop, the Spindletop Center. It used to be called Spindletop MHMR. Spindletop serve the mental health needs of individuals in this area, and they also have a drug and alcohol counseling program called ATAR. Now, with Spindletop, we have a representative from Spindletop who is here in court with us. She'll speak to you in a few minutes. But what they do is they'll come in, they'll do what we call private interviews, Spindletop can do an assessment, and they can develop a treatment plan to address your mental health needs. These are outpatient or inpatient services. Also, for individuals who have issues with drugs or alcohol, Spindletop has a program that is called ATARS, which stands for Addiction Treatment and Recovery. And also Ozar is a local drug and alcohol counseling program that we use as well. They will, ATAR or Ozar, they will do an interview, a screening, and then they can develop a treatment plan, either outpatient or inpatient as well, to meet your alcohol or drug addiction needs. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. And that program is basically work uh, program. It's a program where you are trained, uh, and they will assist you at getting a job. You can get training in the hotel industry, the shipping industry, or the chemical industry. And once you get training in those areas, they will assist you to get employment in the area that you are trained in. And the CICE program also has a GED program. So if you do not have your high school diploma, they can assist you with getting your high school diploma. All of those programs that I've just mentioned are free. It does not cost you anything to get into the programs and to participate in the programs. The other thing about those programs that I just mentioned, all of those programs that I've just mentioned in the CSI program, the program that with Spindletop, the mental health services, the ATAR or OZAR program with uh, drug and alcohol counseling, the GED program, the job training program, and the job placement program. All of those programs are free. It does not cost you anything. And all of those programs can be used as community service towards your fine and fees and court costs. So what that means is you can be doing one thing, but you're getting credit for three things. In essence, we say you could kill three birds with one stone. And what I mean by that is this. Say if you getting some mental health treatment, or you're training for a job, or you're working on your GED, or you're in counseling for drugs or alcohol, that's one thing. 1 hour of that will go toward community service every hour that you sit in the program, and $12.50 will go toward your fine and court costs. So you're doing one thing, but you're getting credit for three things, and the program is free. And so I tell people this all the time. That's a program that's uniquely available in this court. And so I tell people this here: when you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court. And we're trying to make a difference in Jefferson County, in the community in which we live. Now, also in county court at law number 2, we do not just arrest the problem, we address the problem. And also in county court at law number 2, we don't just give time. We take our time, and we are producing productive people, because we believe that productive people do not commit crimes. And so therefore, that's why I started the Community Safety Initiative, the CSI program, in March of 2017. Now, if anybody's interested in the program, just let us know, and we'll be happy to direct you to whatever area you're interested in. If you're interested in mental health services, if you're interested in drug and alcohol treatment or counseling, if you're interested in a GED, or if you're interested in the job training or job placement, just let us know, and you'll be directed to the proper person who can help you, assist you with the needs that you have. Now, we have someone here who is with Spindletop, and she's going to come forward and just tell you what they have to offer in that Spindletop program through the partnership that we have with Spindletop. At this time, would you come forward?
Thanks, Judge. Good morning, everybody. My name is Shelby. As Judge Holmes said, I'm here on behalf of Spindletop Center. We are the local mental health authority. I'm here to see how I can connect anybody to services, whether that be mental health or substance treatment. At Spindletop, we do a range of things: treating mental health, treating substance use disorders. But in addition to that, we have various programs that you can be eligible for. The first step to seeing what you're eligible for would be an intake, and anybody that is interested in doing an intake, I could get you connected to that today. In addition to Spindletop, I have a colleague here, well, he's in the other court, but I have someone here from the Military Veteran Peer Network. He works specifically with veterans and getting them connected to, any types of, any types of services. In a few moments, I'll just come around and get some information from everyone. Does anybody have any questions?
Okay, thank you. Now, ladies and gentlemen, what we're going to do, you filled out the paperwork, and we're going to have our staff come and pick up the paperwork from you. And they're going to go over the paperwork to make sure everything is filled out correctly. Now, there may be an additional, maybe some additional paperwork that you would have to fill out, but this is going to take a little time. So be patient with us. Now, let me tell you this here. We don't want anybody to leave the courthouse, okay? Because if you leave the courthouse while we're still in session and you don't come back, your bond could be forfeited, which means warrant could be issued for your arrest. So, but if you need to go to the restroom or do something like that, you can do that, okay? But just hold on a few minutes, and the court staff is going to come by and help you to, they're going to come and pick up the paperwork, okay? So at this time, we'll be in recess.